So, should the Supreme Court be reviewing the entire issue of the release of those who were convicted for gang rape and murder? Should they be re-looking at this entire case? That's what we are raising. Did the remission violate norms? Will Bilkis Bano ever really get real justice and a sense of closure? Tonight we brought together the two lawyers who appeared for two sides. Shobha Gupta has been Bilkis Bano's lawyer, fighting for her for years now. And Rishi Malhotra is a criminal lawyer at the Supreme Court who argued for the convicts. Let's turn to both of you on this. First to you, Shobha Gupta. Is a judicial review, in your view, the only logical next step? Today, petitions were filed, but they were filed by concerned citizens and politicians, not by Bilkis Bano herself. I do believe that this is a fit case for judicial review.
It's a fit case for judicial review. And as I have been saying, like I've spoken to you before also, let as many as of us come to court. Why not? Like, I'm more than happy that citizens are getting up and they are reaching out to court with whatever nature of the petition. And whosoever, see, somebody can be a politician or somebody can be somebody from some other profession. As long as people are actually reacting to the order and the society is gelling together to tell Bilkis that you need not to each time come yourself and take it up. We can do it for you.
But Shobha Gupta, the fact is Bilkis has locus. She and her family have locus. They will feel that they are the aggrieved party. On the other side, the politicians and the other well-meaning individuals who may intervene may not have locus. Do you believe that Bilkis Bano will have to eventually come to the court to make her voice heard?
So if that need be, she would certainly come. Let's see what happens with these petitions in court. If, like, she's not shying, it's not as if she can live with this order. She can't live with this order.
She can't live with this order. Let me get that clear. She cannot live with this order. Why? Why can she not live with this order?
How come, like, what is this question, Rajdeep? Like, am I supposed to answer this question that why can't she live with this order?
What is it? What is it? What is it? The fact, is she worried about her safety? Is it just the anger that the very people who gang raped her and murdered her 3.5-year-old daughter along with others have been let free after 14 years? Is this out of anger? Is this out of fear? That's what I'm asking.
Assume for a moment there is no fear. Assume for a moment. Can this order, this remission order, which completely zeroed down a whole trial process, they were already dealt with so liberally when they were not given the death penalty, which was the maximum punishment available for the offense they have done. Is it not necessary for the convicts or the accused to be dealt with sternly or to dealt with properly for the punishment which is needed to be given to them? Those are the additional factors. That the impact on the society, impact on Bilkis, her fear factor, the possibility, whatever apprehension she has, and other things. For the timing, let's forget that. But can, in this nature of crime, a remission come in 14 years? Was it a case for remission at all? Is it a law that in all cases where the accused or convicts approaches the committee or the state government concerned, they must be granted remission? No, that's not law. Law says remission is not a right. Remission you can ask for if the committee considers all the factors as a mandate. For me, to begin with, this is not a case for remission at all. They were already given the clemency, they were already dealt with very liberally when they were not given the death penalty but life imprisonment only.
And they have also been granted parole several times over the last 14 years. They've regularly come out of jail. You know, Mr. Malhotra, you explain to us, why should those who have been convicted for gang rape for murdering a 3.5-year-old daughter in front of her mother, along
14.
with others. They don't get the death sentence, they get life. And now they get remission? Do you believe that there was sufficient application of mind, Mr. Malhotra, when this remission was granted? Or do you believe this remission has been done keeping in mind the political considerations, especially in Gujarat, where elections are a few months away?
Absolutely. May I just answer in 5 minutes now? Now, talking about the petition which has been filed in Supreme Court, it's legal absurdity in its best form, and that too by a top-notch legal eagle. Criminal law jurisprudence categorically states that a third party has no locus standi in criminal jurisprudence at all. I can understand if a victim or a complainant, they can approach the Supreme Court or the High Court, whatever the case may be. But a third party, and that too on a political masters, they are approaching Supreme Court in a criminal jurisprudence. It's completely unheard of, and Supreme Court has deprecated this practice time and again. That's point number one. Point number two, I have an occasion to see that petition, and let me tell you very interestingly, the petition says that they don't have the copy of the remission order, and yet they challenges a remission order saying that it may be bereft of this thing or it may be bereft of that thing. I really fail to understand what sort of petition has been filed. Is it a Taliban rule or is it the jungle rule? That they don't know what is the factors which has gone for a remission order, and yet they challenge a remission order, and they seek that all these convicts should be put back to jail.
You tell me,
and
I
yet
asked
they
you
don't make us all the 11 accusers parties in
Mr.
this
Malhotra,
petition.
I asked you a question whether on what grounds do you believe that the remission is justifiable given the horrendous nature, the utter bestiality of this crime, sir. On what basis do you believe? Not once have any of these individuals shown even a fraction of remorse.
Absolutely. Yeah. Now let me explain the second aspect now. The Jail Advisory Committee, which has recommended release of these prisoners, consists of 10 members, which consist of a district and session judge, a district magistrate, senior superintendent of police, 3 social workers, 2 MLAs, and other social organization. So it's a 10-member unanimous decision which has let out these persons after they have served out actual sentence of 15 years and more. Not only that, the requisite requirement of the central government in these cases have been taken with approval. So I really fail to understand that when all the requisites, all the norms as per 1992 policy which is applicable at time of conviction has been taken care of, why this hue and cry at this stage when the man has been released
Malhotra,
after 15
the
years of actual
decision,
sentence?
sir, 1 minute. There were 10 people on that committee. 5 of them are affiliated to the BJP, including 2 MLAs. That's the fact. The fact also, Mr. Malhotra, is that questions can be raised whether there was sufficient application of mind. I asked you a simple question. Have any of these convicts ever shown any remorse for their action? Do you agree that gang rape and murder is the most horrendous of crimes that have taken place? Do you concede that or not, sir?
Absolutely. Rape and murder is a dreaded crime. There is no running away from that. But please don't forget,
yes,
when the convicts were not awarded death sentence either by the High Court or by the Supreme Court, there was no hue and cry by anyone or so-called social activities which are now cropped up once again. So why now, after they have served out actual 15 years of sentence, the desired period of sentence which they were required to serve was 14 years only, despite that they have served 1.5 years more, and now they want to get reformed and rehabilitated? Why this hue and cry now at this stage? I really wonder about this,
okay,
this type of
let me put that to Ms. Gupta. Let me put what you just said to Ms. Gupta. Ms. Gupta, here you've got Rishi Malhotra saying why the hue and cry now? They were not, death sentence was not given, they were given life. They've completed 15 years in jail. Therefore, they have every right to rehabilitate themselves after the same Supreme Court says every sinner has a future.
Before answering that, can I ask Rishi? Rishi, do you have the copy of the order, remission order?
That's the point. Nobody has the copy of the order, yet a petition has been filed challenging the order.
Thank you for
This is
clarifying,
Supreme
Rishi.
Court.
No, 1 minute, 1 minute. Are we telling, just a minute, are we telling the viewers of this country, the people of this country, that neither the lawyer for Bilkis Bano nor the lawyer for the convicts, even today, 1 week later, has a copy of the remission order? Is that what we are saying, Mr. Malhotra? You have a copy of the order, remission order given by the Gujarat government, stating the reasons? You have it? Yes or no? Yes or no, sir?
Rajdeep, please appreciate, a petition has been, nobody has the copy of the remission order, and that's what the prayer in the so-called writ petition is.
Okay.
That please supply us the copy of the order and set it aside.
No, but what does it say?
8
days, sir.
This is unheard of,
sir,
actually.
they were given remission on the 15th. We are on the 23rd of August. Are we saying in this country that 8 days later, the Gujarat government has not even given this remission order to the lawyers in public? What is being hidden?
So I'll answer.
Yeah, please
Nothing
answer.
has been hidden. They can always apply, as Shobha told, they have moved an RTI for a copy of the remission order.
Okay, so RTI has to be moved for a copy of remission order, but go ahead, Shobha. Okay, ma'am. Okay, sir, let Shobha respond. I'll come to you.
So, since my friend Rishi was referring in detail about what must have been gone into by the committee, I thought he has the occasion to read the order. So, luckily it seems even he like, here we are equal. Even he does not have the copy of the order. We don't have the copy of the order. We have applied now under RTI. And I'm just hoping that in a day or two they give it us. We have written to them directly also, through RTI also. We don't have the copy of the remission order yet. So
Are being asked to file an RTI. Are you saying, Shobha Gupta, you are being asked to file an RTI to find out the remission order? Is that what you've gone and done?
I have. We have. Bilkis has submitted the RTI application yesterday.
Let me also get this clear, Shobha Gupta. Am I correct in saying that this 10-member committee at no stage consulted or spoke to Bilkis or her family members before giving the remission? Is that right?
Not at all.
At no stage?
Not at all.
Is that unusual?
This news broke to us on 15th when they actually came out. 14th, certainly Yaqub called me and he was asking, ma'am, is there something, there's a feeler in the village, people are talking like this, they might come out any day. It seems Supreme Court has given them some relief. So there were feelers on 14th and 15th they were out. Not once anybody approached Bilkis, no notice, no information. Now, my friend was talking about right to rehabilitate. Right to rehabilitation to whom? Who had no mercy, no humanity. The wilderness of highest order of killing 14 persons before killing, actually raping, gang raping the women there. The deceased include a one-day-old child also, one-day-old child. The daughter of Bilkis was smashed in front of her eyes. She was begging to those accused, I am daughter to you, I am sister to you, my daughter is like daughter to you, we have been interacting, we were in the same village. They were much elder than, double of the age possibly, or actually much elder to her. She was begging to them for mercy. We handle a pregnant woman like in a air bubble.
But Ms. Gupta, the fact, Ms. Gupta, your story is driving me to tears again, but the fact is that section 434 and 435 of the Criminal Procedure Code does allow any of the convicts to approach the court, which they did. It allows the court to pass the matter on to the state government, which they did, and for the state government to grant remission. That is the law and the procedure.
So there's the catch. Enabling provision is not a mandatory provision. An enabling provision, the policy says if you have completed minimum 14 years, you can approach us. It does not say nobody can be kept behind bars beyond 14 years. It was a window to be opened for an application to be submitted for consideration of remission. Supreme Court again and again, I can put a lengthy list of judgments, including 5 judges bench judgment, which says remission is not a matter of right. It's something you can ask for, factors to be considered.
It's a matter of discretion. It's a matter of discretion.
Mandate is what? Mandate is to look into the factors which is mandatory.
Okay.
What is the mandate? Nature of the crime. The method of conducting the crime. The remorseless, forget remorseless. Impact on the society, impact on the individual. Their conduct, sentence undergone. The safety concerns of the victim. We have yet to see, but believe you me, my sense of reasoning fails me completely if I put everything together. Can any person having some reasons in mind can grant this remission at all? There were 10 sitting together.
Rishi Malhotra, you want to respond to that, because the fact is that here is the victim of a horrendous crime who's not even consulted before her, at no stage, consulted before her victims, her fears, her anxieties, her apprehension, her sense of justice is not part of this 10-member committee, whose remission order, as both of you have acknowledged on the show, is not even now public even today. So either the government has something to hide, or...
And we are in digital India.
Okay, just a minute, ma'am. Rishi Malhotra, therefore, just given that nature of the crime, what is the main reason in your view why they deserved remission? Simple, straight question. In your view, why do you believe they deserve remission?
Yeah. No. You see, before I answer this question, let me make some facts which is clear and which is not in dispute. There were 2 policies of state of Gujarat which are in question as on date. One is 92 policy and other is 2014 policy. 92 policy and 2014 policy both talks about that the convict should undergo a minimum sentence of 14 years actual. That's not in dispute. 92 policy says that in order to be case for consideration for premature release, there will be an advisory board consisting of 10 members, which I just spelled out earlier, and then they will take a decision whether to consider granting of remission to a convict or not. 2014 policy, there was some departure from 92 policy, which said that in certain category of cases like rape and murder, a convict may not be released for premature release for all times to come. Now, the Supreme Court in May 2022 passed a detailed judgment saying that in this case, since the trial court has convicted the convicts in 2008, so therefore a 92 policy which was still being governed will be applicable in this case. Now, today, what was mentioned by Kapil Sibal before the court was that we are not challenging, I am repeating this word, we are not challenging the Supreme Court judgment of May 2022. What we are only seeking is to place on record the copy of the remission order. And the further play is that while putting on record the copy of the remission order, let it be set aside without seeing any reasons. And coupled with this thing, the beauty of this thing is that the relief which has been sought against 11 accused, they are not even made parties to the writ petition. And a petition has been filed by a political master, and the allegation against the advisory committee is that it consisted of 5 BJP MLAs. So what about this petition which has been filed by a CPIM and other so-called political masters? Nobody is touching upon that.
You are a very fine lawyer.
Why can't the complainant can approach the Supreme
Court?
No,
you're a very fine lawyer. There will be 2 issues though. Sir, just a minute. You're a very fine lawyer, but 2 issues can still be raised. That the Supreme Court, in its May order, allowing the state to use discretionary powers, said you can go by the 1992 rule because the gang rape took place before the 2014 new rules that do not allow remission for rapists have occurred. So therefore they've gone by the 1992. I can challenge that in court, or I presume someone will. Number 2, you are saying that it is now a petition being filed by one political party or grouping versus the other. But the fact is, at the heart of this is a woman who at the age of 21, when she was a few months pregnant, was gang raped and her 3.5-year-old child was murdered in front of her. That is not disputed. And therefore the question arises, what is the precedent that is being set if they are granted precedent? Not once has your client shown any remorse And therefore I ask, if they had shown some remorse, some willingness to rehabilitate themselves in the truest sense, instead of being garlanded and giving sweets, I would have accepted your argument, Mr. Malhotra.
No, I really, Rajdeep, just a minute. I really wonder where is it coming from that they had no remorse or they had no intent to rehabilitate themselves. This is just a speculative debate, nothing else. 15 years a man has undergone as an actual custody. Don't you think that he has a right to have a rehabilitation and reformation? Otherwise, why did the Supreme Court or the High Court did not award death sentence if the Supreme Court would have thought that it was such a grossest case ever in the history of India? The Supreme Court wisdom nobody can challenge. Neither the Supreme Court wisdom in 2022 judgment can anybody challenge. Even the other side made an appeal before the Supreme Court today before the Chief Justice Court that they don't intend to challenge the Supreme Court judgment.
Can you show me one statement on record of any remorse?
No, that's what I'm saying. How is it presumed against my clients that they have no remorse? Nobody has the record in front of them. Nobody has the remission order in front of them. Yet a petition is filed that how come remission was granted. This is actually an absurd. Talking about any neutral case, forget I defended the accused.
Okay, so you're saying, how can you go to the remission? How can you go to the court with a petition seeking to reverse the remission order without even having the remission order in the first place in your hand? The fact, though, is, as I repeated at the outset, 8 days have passed.
And to add on this, without knowing the reason whatsoever.
Okay, we don't know the reason. We prima facie, because of the nature of the crime, believe it could be non-application of mind. It could be political considerations. Either way. Sir, either way, I am a father, as you are, as many people watching this show are, who will ask themselves this question tonight as they sleep. Is this the kind of justice system we want in this country, where a precedent is being set, where those convicts who've served 14 years but have never shown any remorse, or at least none publicly, are being let off because Section 434 and 435 gives discretion to a government whose 5 representatives are those who are seen to be ideologically aligned to some of these convicts in the context of what happened 20 years ago. 20 saal baad, this country must ask itself tonight and wake, and if you tell me move on, go and tell that, look at Bilkis Bano in the eye and tell her to move on. It is for her and her struggle that we must fight this campaign as right-thinking Indians. Because today it's Bilkis, tomorrow it could be anyone else in the country. The Supreme Court must lay out clearer parameters for when remission is to be granted. It cannot be arbitrary. It cannot be in this way. Shobha Gupta, Mr. Malhotra, I appreciate both of you joining us. I know that you're lawyers, but we are all human beings above all else. And it is that humanity that needs to shine through in a case like this. Please think about it tonight.